This is Eye on Bankruptcy, brought to you by the American Bankruptcy Institute. Here is Professor Juliette Morangello of Widener University Commonwealth Law School.
Hello and welcome to another edition of Eye on Bankruptcy. I'm Juliette Morangello, the Commonwealth Professor of Business Law and Director of the Business Advising Program at Widener University Commonwealth Law School in Harrisburg, Pennsylvania, and your host. Eye on Bankruptcy is a monthly show of current legal developments produced by the American Bankruptcy Institute. We come to you from ABI's production studio in Alexandria, Virginia, just outside Washington. Our website, eyeonbankruptcy.com, contains an archive of more than 24 programs featuring leading practitioners, judges, and scholars. The show qualifies for an hour of CLE credit. Today we focus on bankruptcy and appellate court opinions from September and one case from October. Included are several of special note for both commercial and consumer practitioners. We are honored and delighted to have with us two guests well qualified to speak about these cases. Keith Phillips was appointed to the busy bankruptcy court for the Eastern District of Virginia in 2013, sitting in his native Richmond. Prior to his appointment, he was in private practice representing debtors, creditors' committees, and trustees in all chapters under the Bankruptcy Code. He also served as a mediator in bankruptcy-related disputes, as a Chapter 7 trustee on the Richmond panel for about 27 years, and as a Chapter 11 trustee, liquidation trustee, and state court receiver. The Richmond court has attracted some major retail cases. Judge Phillips is presiding both over the Toys R Us and Gymboree cases and received a poignant and well-publicized letter from a 9-year-old urging Toys R Us to stay open. Young Andrew made some pretty good arguments, which the court has under advisement. Judge Phillips graduated from the College of William and Mary and from the University of Richmond Law School. Our other guest is Erica Morabito, a partner, litigator, and restructuring lawyer at Foley & Lardner in Washington, D.C. Erica represents Chapter 11 debtors, creditors' committees, Chapter 7 and Chapter 11 trustees, and federal court-appointed receivers. She advises clients in creditors' rights litigation, avoidance actions, claims disputes, out-of-court restructurings, and the purchase and sale of assets under the Bankruptcy Code. A frequent presenter at CLE conferences, Erica serves on the advisory boards for the Georgetown Views from the Bench and the ABI's Mid-Atlantic Workshop. She earned her degree with honors from Syracuse University. Her undergraduate degree is from Oswego State University in New York, where she was also an NCAA scholar athlete. Thank you both for joining me, and welcome to Eye on Bankruptcy.
Thank you.
Pleased to be here. Thank you.
Okay, so we have a lot to discuss today. So our first opinion, In Re Hungry Horse LLC, is from the Bankruptcy Court for the District of New Mexico and addresses the scope of the Supreme Court's 2015 opinion in Baker-Botts versus Asarco. The court in Asarco, as many will remember, held that Section 330 of the Bankruptcy Code does not allow a court to award compensation to an attorney for defending its fee application because 330 is not a statutory exception to the American rule that each litigant pays its own attorney's fees. After Asarco, bankruptcy professionals began including fee defense provisions in their fee agreements. In Hungry Horse, the debtor sought court approval under Bankruptcy Code Section 328A of the engagement agreement that it had entered into with its bankruptcy counsel. The agreement provided that debtor would pay all reasonable fees incurred in obtaining court approval of all employment and fee applications, including dealing with any objections to any of the applications. The Unsecured Creditors Committee objected to the fee defense provision as contrary to the holding in Asarco. The court in Hungry Horse, analyzing the interplay between Sections 328 and 330, held that the fee defense provision is a reasonable term under 328A and as such does not violate the letter or the spirit of Asarco. And not all courts are coming out this way. In Boomerang Tube, the Delaware Bankruptcy Court held that Asarco prohibited this kind of fee agreement. Of course, Hungry Horse came out the other way. So which is the better approach?
Well, So it's a good question, right? Obviously, we're all very familiar with ASARCO and Boomerang, and from a practitioner standpoint, it's challenging because if your fees are being questioned, obviously it's important for us that if we have to defend, should we have the ability to get our fees back? I think Judge Walrath in Boomerang made it pretty clear under the circumstances and citing ASARCO that it wouldn't make sense because it's not in the best interest of the estate. It's only in the best interest of the attorney. Interestingly, in Hungry Horse, which is a much smaller jurisdiction, and I think that certainly went into the decision making by Judge Thurma, it seemed to appear that if it's working in our jurisdiction and I still have the ability to be able to assess the fees at the end, then I don't see it as an issue. And some of the things that Judge Thurma cited on, I think that practitioners agree with, is it's going to help bring bona fide disputes. And I think that's important because there's certainly a leverage play that can be done against an attorney that could give that person an unfair advantage if they were threatening, challenging the fees, knowing that you're not going to get your fees back. So I don't know, Judge Phillips, I know you certainly look at this issue sometimes, and obviously, Judge Thurman came out differently than Judge Walrath, and
Well, I think Judge Thuma gave all the right reasons if you're looking for a way to avoid the ASARCO decision. Although it is hard to disregard the language of ASARCO and the language of Section 330A, and I think you're going to have to look at this case as something of an outlier. You mentioned that it's a smaller case or a smaller jurisdiction, and I know that courts get used to implementing the bankruptcy system a certain way, and if it works, there's oftentimes resistance to changing the way things are done. People get used to it, it works, why change it? And in New Mexico, apparently this is how things are done, and it's worked, and he gave a number of good reasons why the system is working and how you can monitor the concerns that are raised in ASARCO. He said, as in the opinion, some of the reasons for allowing the 328 exception is it enables clients to hire able professionals. Many retention agreements include provisions that are beneficial to the lawyers. Why shouldn't a contract in this case also be have those types of provisions? It may help limit abusive fee challenges, which is something you raised, and which certainly is the one of the largest arguments to consider on the other side. And then he laid out some reasonable criteria that the debtor has to approve the fees. In this case, I think it was debtor's counsel. Committee counsel must be similarly protected. And if there is an unsuccessful challenge, then the fees aren't allowed.
right, exactly.
And so that would hopefully discourage unnecessary challenges. And then there's also a situation which I think is even applicable in light of ASARCO, and even if you don't go this way, where if it's abusive enough, there's potential Rule 11 sanctions that can be awarded. So, so there's an opportunity to deal with the abuse concern, even if you don't follow the decision that was implemented in this case. But as I said, I think it's a bit of an outlier, and one of the reasons I mention it is because there was another case reported on the Rochelle's Daily Wire. So you saw that?
Just the other day,
Right, right.
Yep.
And that's a case out of the Fifth Circuit, NRA Valence Technology, Inc. And that case involved a Chapter 11 fee for a investment banker who was entitled to, under the retention agreement, to get a success fee. This was a Chapter 11 case that involved a swap of debt for equity. The bankruptcy court determined that the investment banker would be entitled to the fee, but did not award the fees that were incurred in connection with the challenge. And the reason that the court denied the fees, it was based on ASARCO, but it was also because the attorneys representing the investment banker were not previously involved in the case. They had not been employed pursuant to a court order, and therefore this court said that that they were not entitled to compensation out of the estate. But I think what it does is it establishes that that generally courts are going to go with the SARCO and look at the reason that case was decided the way it was, and that is that if there's no benefit to the bankruptcy estate, then typically those fees aren't going to be allowed.
Yeah, what I thought was interesting, and you alluded to it, Erica, was that the court noted the small size of and small fees in bankruptcies that are filed in New Mexico, and certainly the judge's point that if the fees aren't of benefit for the estate, they shouldn't be approved. But should the fact that these are smaller cases and the fees would eat up so much of the attorney's fees have influenced the decision?
I mean, that's a good question. Judge Phillips and I talked about this a little bit as well because, and I won't speak for the bench, but from the judge's perspective, everybody kind of has their unique challenges no matter where they are sitting on the bench. So you can certainly understand why that would play in. But looking at from a larger scope, if this is going to be a precedent-setting case, I think that's a slippery slope. I mean, who ultimately is going to determine when it's small enough, when it's not small enough? I think we have enough confidence in the bench that different kinds of facts and circumstances are going to be taken into consideration. And I think from a practitioner standpoint, even though the courts in Boomerang and in Sarco came out the way they did, I think that if you still put the provision in your retention application, I think that's smart. Because I do think, going to Judge Phillips' point, that if, for example, you are being leveraged and someone is threatening a non-bona fide dispute, if you will, if you're not giving them certain preferential treatment, and you do have to litigate your fees, maybe then you look beyond 328 and 330, and even though it might not have benefited the estate, if ultimately your decision to not give somebody an unfair advantage benefited the estate, then you might be able to look beyond that. And if truly it's something that could rise to the level of a Rule 11, then you might be able to be compensated as a result of that.
Yeah, that's a great point.
Another concern I had with the 328 basis has to do with the notice requirement that 330 has embedded in it. There is no similar notice requirement under Section 328, and I recall cases when I acted as a Chapter 7 trustee, we typically would submit applications for employment of professionals, and the U.S. trustee would review it and endorse the order, and the court would enter it. But it wasn't served on all creditors and parties. And so how do they have an opportunity, a real opportunity to object to whatever provisions are in the retention agreement prior to its being implemented through the appointment?
Right.
So that could also, I think, at least from my perspective, open the door to a subsequent objection. If a creditor was not previously notified of the language in the retention agreement, then seems like they ought to have the opportunity to come in later and complain about it.
Right. And another thing that you mentioned, Erica, and I think actually you both did, was the roadmap that the court set forth for approval of these fee agreements. So if a court were inclined to approve them, do you agree with the roadmap that the court set out here?
I mean, I think it's a workaround,
Yeah.
328A. I mean, I think that's the whole purpose, so that in some mechanisms, the result there is justified by the roadmap. Whether or not that's, I mean, part of the roadmap I think makes sense, which is ultimately the court has the ability on any fee that's submitted to decide if it's right or if it's wrong.
Right.
So if the fees come up, and like we talked about, if it looks like this was something that truly needed to be defended and it wasn't a bona fide dispute, then the court has the discretion to decide that. They also have the discretion to decide if the amount is reasonable. So certainly with that particular part of the roadmap, I think it's important. Getting to Judge Phillips' earlier point on notice, I mean, one of the things they had in the roadmap here is make sure you get bankruptcy court approval. So whether it's coming down to notice, if you're distinguishing between 330 and 328, or it's coming down where you don't include it in your application and then you're seeking it on the back end, I think you're going to lose on that. So I think the roadmap is trying to lay out, the best opportunity that if you follow these, then at least you'll have a chance to try to convince a judge to do something different than what was done in Sarko and Boomerang.
Sure.
Yeah, I expect the roadmap is consistent with what the practice was in this court before this was challenged and subsequent to the Sarko opinion, and it worked before, so why wouldn't it work now?
Yeah. Okay. Well, I think this is probably not the last we're going to see of this issue. So thank you. And let's move on to our second opinion, which is about surcharges. So the second opinion, in re Nettel Corporation, is from the Bankruptcy Court in the District of Columbia, and it addresses a matter on which courts are split. The trustee in this Chapter 7 case, which had been converted from a Chapter 11 within a month of filing, the trustee filed his final report that proposed a final distribution of the remaining money in the estate toward payment of administrative expenses. The estate was insolvent, and no administrative claimant was going to be paid in full. The trustee proposed that he and his law firm receive over 98% of what they were owed. Other administrative claimants would be paid around 62%. The additional money going to the trustee came from a surcharge on the secured creditor's collateral. The trustee argued that under 506C, the proceeds of the surcharge were payable only to the administrative claims that provided the benefit to the secured creditor's collateral that justified the surcharge. The U.S. trustee and one of the other administrative claimants argued that 506C is a recovery provision for the benefit of the estate. The court ordered the trustee to disgorge a portion of his interim fees to enforce the pro rata distribution. So this is one on which courts are split. The Ninth Circuit adopted the position that the trustee took in this case. The court in Nettel followed the Fourth Circuit approach, stating that the Ninth Circuit approach creates an impermissible priority and that it creates undesirable incentives. So, which is the better position?
Well, let me say for the record, there's three courts that are always right.
The Fourth Circuit.
And one of them is the Eastern District of Virginia. The other is the Fourth Circuit, and of course the Supreme Court. So, of course, this decision, if it's consistent with the Fourth Circuit, is right. Mm-hmm. And I think right not just because it's what the Fourth Circuit has decided, but I think it's right on the analysis as well. And my time with being a Chapter 7 trustee, this issue came up from time to time, and I can think of some of the practical issues that are addressed here. And for example, if you are a trustee in a case and you're looking at doing something to preserve or protect collateral, well, who are you going to hire to do that? Who are you going to pay to do that? Are you going to pay insurance premiums? Are you going to have contractors do work? Are you going to sell the property and enlist the services of a sales agent? And these people providing services have an expectation they're going to get paid out of the collateral.
Right.
By the same token, the professionals that are hired by the trustee in general have an expectation of getting paid as well. And so you don't necessarily want to have some professionals vying with other professionals for payment. But it does raise that practical concern. How do you approach those professionals that you hire to preserve the collateral? And then, if for some reason your surcharge claim doesn't prevail, what do you tell them? Right. You know, you're going to have to take a pro rata share if the estate is administratively insolvent. Or another way of looking at it is, would the trustee in this case have said, well, if I get my surcharge claim, I pay the people who participated and who are contributed to the claim. But if I lose, does that mean they don't get anything? You either get it or you don't. Mm-hmm. And so, what do you tell the professionals or the administrative claimants that have provided the services to preserve the collateral? I don't think you can have an all or nothing. I think that the appropriate way to look at it is the way Judge Teal did, and that is that it's a recovery provision for the trustee, and you're not going to enable some professionals or administrative claimants to potentially get paid nothing or everything, and others who are similarly situated have to get whatever's left. So I agree with this analysis, and of course, you know, this is a two-part case. It deals not only with the surcharge claim, but yes, the disgorgement. Mm-hmm. And the disgorgement, Judge Teal decided on the basis of a case that he had previously decided that allowed disgorgement. In this case, the argument was that that case, that the previous case was prior to Law versus Siegel, and Law versus Siegel would not allow the disgorgement at this time because it's inconsistent with the Section 330, and I don't read Law versus Siegel that way. I think Law versus Siegel basically says that you can't do something that's directly contrary to the provisions of another statute. And this doesn't fall into that category.
Right, yeah, Law versus Siegel is sort of the opposite of using 105 to do everything, and then
Exactly.
people now cite it to say you can't use 105 to do anything.
Exactly.
So, Erica?
Yeah, I mean, I think this is, I see both sides. I agree that Judge Teal came out on the side that I think is more fair and equitable. Bankruptcy courts are supposed to be equity. I think the Ninth Circuit and their analysis sort of subscribes to the victor goes the spoils.
Right.
So I can understand that from their perspective. But if this is truly a court of equity, and that's what the purpose is to make sure that we're consistent with the priority scheme, then I agree with the manner in which Judge Teal did his analysis. Disgorgement's never easy, and I think that's something that courts struggle with, but if you're really going to be consistent on your analysis as to why it should be distributed the way in which it did, then disgorgement's really the only answer.
Sure.
And an interim compensation order is not a final order. But as Judge Teal also points out, not every administrative claimant can seek an interim distribution.
Right.
And sometimes with respect to trustees or counsel for the trustees, I mean, you could have a Chapter 7 case that's going on for quite some time, and it's a hardship on the trustee and counsel to have to wait till the end of the case to collect all of their fees. Some cases justify interim distributions of compensation, but obviously after this case, you should be aware that could potentially become subject to disgorgement in order to equalize all of the administrative claimants' recoveries. I would think that the trustee would understand that and after getting an interim compensation award. But I don't blame him for challenging the ability for the court to do that. But once again, I think that the reasons are not only valid reasons in terms of fairness, but I don't think Law versus Siegel prohibits it.
Right. All right. Anything else on this one?
No?
Okay, let's move on then. And the next one is a First Circuit case that deepens a circuit split regarding the right of an unsecured creditors committee to intervene in an adversary proceeding. This case is one of the cases arising out of Puerto Rico's financial distress. Assured Guarantee Corp versus the Financial Oversight and Management Board for Puerto Rico arises under PROMESA, which is the special non-bankruptcy bankruptcy law for Puerto Rico, which of course incorporates many provisions of the Bankruptcy Code, including Section 1109B, which is at issue in this opinion. So according to 1109B, a party in interest may raise and may appear and be heard on any issue in a case under this chapter. The 4th, 5th, and 10th Circuits have held that this language does not provide a statutory right to intervene in adversary proceedings. The First Circuit agreed with the 2nd and 3rd Circuits, which hold that it does. Here, the plaintiff bond insurers had brought an adversary proceeding alleging that Puerto Rico's fiscal plan violated both PROMESA and the United States Constitution, and seeking an injunction prohibiting implementation of the plan and a stay of the confirmation of any plan of adjustment. The district court denied the creditors committee's motion to intervene, and the First Circuit reversed. So I know that the Fourth Circuit is always right, but
You guys heard that, right?
But did the First Circuit, in holding that 1109B provides an unconditional right to intervene, did they come down on the right side of this circuit split?
So I'm gonna the Fourth Circuit's always right, so I want to say that, but I'm gonna give the First Circuit a shout out here because I do believe that 1109B does give them the right to intervene. For me, the right is more akin to a standing argument. And, I'm a big follower of Collier's, and whenever I have questions, I always look to see what Collier's is how they're going to come out on this. And I think it's clear. I mean, I represent committees, and I think I understand what our role is, and that we have the greatest stake in the outcome for the most people on this particular case, and that we're kind of the checks and balances. And I mean, if you read 1109B and it says the committee may be heard on any matter in this case, to me that almost gives you an unqualified right to intervene. If I take that bankruptcy statute and then apply it to my federal court practice, and I've certainly represented parties where we were seeking to intervene before, I have to first establish the basis for intervening. Versus in bankruptcy, I have 1109B, and so I feel like the committee can intervene. So then you get to the second aspect, which is, well, what scope can you be intervening? Should that be limited? And in this particular case, I don't think the First Circuit addressed it head on, because I don't think they had to, because I think the committee came in and had already limited its scope. But I think that, the committee saying we need to be involved because that's what our role is in this, to make sure that we are looking out for the stakeholders and to provide some sort of balance to what the debtors and other parties are doing. But we're not asking to have the same role that the parties involved in the dispute have. We're saying we should sit in on the depositions, but we're not going to take the depositions. We're saying we should have the ability to file briefs and be heard. But I think if it's a limited scope, I think 1109B does give them the right. I think it goes back to my earlier argument on equity and making sure we have checks and balances. And I don't really see a harm in it if, in fact, the scope is narrowed.
The First Circuit basically said that they had a prior case where they were in a footnote, they had indicated that the rule would go the other way, that they were basically taking a new approach to this question, and that the district court that had followed the footnote in the circuit court's opinion, in Ray Thompson, an earlier decision, that interpreted 1109B to not afford a right to intervene, was just dicta, not binding, and they can come down the other way. So if the circuit court says that the decision is dicta, that means it's not really their decision. They can come up with another decision that makes more sense, which comes back to the Fourth Circuit, because I think the Fourth Circuit decision is also looked at as dicta. And it's funny because this case, and I think the Fourth Circuit case as well, involved Chapter 7s.
Correct.
Which I suppose meant that at the time these issues arose, these were Chapter 7 cases where you typically don't have a committee, so
Right.
I'm not even sure why they were being contested at that point. But I think it's really, at the end of the day, I'm not sure it's a huge issue, because if there's a reason for a committee to be involved in a case, and as you said, Collier says case means the whole ball of wax,
Right.
including adversary proceedings, I would expect most courts would grant permissive intervention, and but even if the court is required to grant intervention rights because it's an unqualified right under 1109B, there's still the ability to limit the participation, and so that's really, I think, the key, because the court can control the committee's actions by limiting that participation in a way that makes sense.
Yeah, and the opinion certainly makes that clear. So,
Right. And I wasn't sure why the apprehension about having the committee involved. I mean, I couldn't tell from reading the case if it was a concern on fees, and that they were concerned that by additional committee participation that was going to be an additional burden.
Right.
But that would be an interesting thing to know, because
Yeah.
I'm not exactly sure from reading the case why there was so much apprehension about wanting the committee to participate even in a limited scope.
point. All right. Moving on, we have another opinion that wades into a circuit split. In Slater versus U.S. Steel, the 11th Circuit en banc weighed in on how the doctrine of judicial estoppel should apply when a plaintiff takes inconsistent positions by pursuing in district court a civil claim that she failed to disclose in her bankruptcy case. The plaintiff in this case worked for U.S. Steel, doing what the court described as basic manual labor. She sued U.S. Steel for race and sex discrimination, and U.S. Steel moved for summary judgment. The district court denied the motion in part. A month later, the plaintiff, represented by different counsel, filed for bankruptcy, and she failed to disclose the lawsuit as an asset. U.S. Steel again moved for summary judgment on the ground that because Ms. Slater failed to disclose the lawsuit, the doctrine of judicial estoppel should bar her from pursuing the claim. This time, the district court granted summary judgment. Under circuit precedent, a court would apply judicial estoppel when the party took an inconsistent position under oath in a separate proceeding and the inconsistent positions were calculated to make a mockery of the judicial system. Previously, the courts in the 11th Circuit inferred that a debtor who omitted a claim from her schedules intended to make a mockery of the judicial system. The court in Slater held that in deciding whether a plaintiff intended to make a mockery of the judicial system, that the court would need to review the totality of the facts and circumstances. And here, the court lists a number of factors that a court should consider in determining whether a plaintiff's failure to disclose is calculated to make a mockery of the judicial system. So, are these the appropriate factors, and is this the appropriate approach?
Well, when I was a Chapter 7 trustee, this judicial estoppel argument was a real thorn in my side. I mean, what you would have, for example, is a case where a debtor fails to list a cause of action. And so as a trustee, you work hard to discover that that cause of action exists. Aha, debtor, you didn't list something, but I found it anyway, and I'm going to administer that asset. And I'm going to do it for the benefit of the creditors in the case. But as a result of this judicial estoppel argument, now I can't do it. And it's all because the debtor did something, in some cases, that the debtor shouldn't have done, and that is try to conceal the existence of an asset. In Virginia, what's interesting is that there's a exemption under Section 34-28.1 of the Virginia Code that exempts any proceeds from a personal injury action from the estate. Why would anybody not list an asset that's exempt? But you'd be surprised how many debtors didn't list the asset. And sometimes it was because they didn't understand the question.
Right.
Sometimes it's because there was a lawyer representing the debtor that said, well, it's exempt anyway, you don't need to list it. And so it wouldn't be listed. Well, I mean, there isn't any insurance lawyers or any defense lawyers now who don't check PACER in a case that they're defending. I mean, you always check to see if the debtor filed bankruptcy. Why?
Right.
Because you can potentially make this judicial estoppel argument. And so what would happen, at least in Virginia, is that you find the asset. You might even have the right to object to the exemption because the debtor didn't list the asset, and then you can't pursue it. And it may be because you're stopped because the debtor didn't list it, but it might also be because you don't have standing. Right. Because that's the other argument defense counsel makes. It's not your claim, you don't have standing to pursue it. Or more often, the debtor doesn't have standing, only the trustee has standing.
Okay.
So the debtor doesn't have standing to pursue it, only the trustee has standing. What happens is the case is over, nobody knew about it, the debtor picks it up and starts pursuing it. Defense counsel comes in and says, you didn't have standing, we're moving to dismiss. The debtor comes back to reopen the bankruptcy case, to list it and exempt it and so forth. And so that's when the defense counsel comes in and says, well, okay, the trustee had standing, but the trustee can't pursue it either because of judicial estoppel or sometimes because the statute of limitations is run.
Right.
And so it really just ended up being a real hardship on the Chapter 7 trustee. This case is interesting because even though it creates exceptions to this judicial estoppel argument, I'm not really sure it changes a whole lot from what the law was in this circuit to begin with. There's a case, I think it was Parker that's cited in the opinion, where the court indicated that Chapter 7's only the trustee has standing to pursue the claim, and as a result, any Chapter 7 case doesn't, this test is not applicable, it doesn't apply because the debtor can't not make a mockery or inadvertently list something that he doesn't have standing to pursue it, you can't, defense counsel, you can't come back in and argue that it's something that the debtor did because it's the trustee's claim. And so even in the footnote in the opinion, it says, as we observed our holding in Parker, that judicial estoppel should not apply against a Chapter 7 trustee, conflicted with our early decision in Barger, but because we overrule that portion of Barger, Parker no longer conflicts with prior panel precedent, so there's no question about its continued viability. So this case really just deals with Chapter 13 claims now, claims arising in the case of a Chapter 13. And it goes into, it talks about the two-part test, but the second part of the test, whether there was an intention to make a mockery. This case said that you can't just infer that because it wasn't listed. You have to look at all the facts and circumstances. And looking at the facts and circumstances in any case is usually a good idea. But I'm not real sure that it really changed the scope of the precedent in this circuit. In the bulletin that accompanied the case, there is reference to the Fifth Circuit's decision in Reed versus City of Arlington, and that case goes into the unfairness that results from not allowing a trustee to pursue, or a Chapter 13 debtor to pursue a claim. The hardship ends up being on the creditors, and that's not fair, and you shouldn't allow that to happen. So I think that if you look at this particular case and at the Reed case in the Fifth Circuit, you'll find that the tendency among courts now is to look at the circumstances, and if it creates an unfair situation from the standpoint of the creditors in the case, then judicial estoppel may not apply.
Well, sure, and of course that's an excellent point, and the court did talk about the impact both on the defendant who gets off the hook and on the creditors, because a dismissed lawsuit is a worthless asset.
Right.
So I think that's right. Erica?
Yeah, I mean, I agree. It's a totality. If I put my defense cap on, I always have difficulty when there's a scienter requirement and intended to make a mockery of the court. To me, that's a pretty high burden. And everybody knows when you look at the schedules or the statement of financial affairs, sometimes they're clear as mud, right? I mean, I've looked at them several times and I'm not sure how to answer a particular question. In this case, though, clearly it wasn't just an omission. One of the things they also talked about that they looked at in the factors is whether or not they go and correct their schedules.
Yes.
And in this case, she went and corrected the schedules, and we never want to deter somebody from correcting the schedules, but she corrected the schedules because they believe she was caught once the district court, Slate moved to the steel company moved, again, to say now it's collateral estoppel. So did she only correct because of that? Counsel is important in this. Did their counsel know? I mean, counsel's the one that has to review those.
Right.
They've obviously put in a heightened burden on counsel's involvement in having this, so it's just not up to them. So I agree. I mean, you have to look at the factors of each particular case, and I think particularly when you're accusing somebody of an intentional act, like you would in fraud claims, where it's not a statutory right, like in a preference, for example. I think you do have to really drill down on what those factors are in order to come out the way the court did in this particular case.
Yeah, you don't want. I don't think you want to reward a debtor for purposefully not listing the asset in an attempt to conceal it, and that might be when you say that makes a mockery and that satisfies the second part of the test. You're actually doing that. Another thing that would come up in a similar vein in cases where I would be involved from time to time is the valuation that the debtor places on the claim, and having the debtor be held to that valuation. I mean, it was routine for lawyers in cases in Virginia where the asset, if it's a cause of action for personal injury, is exempt anyway, to just to list it, but list it for a nominal value, not knowing what it's really worth.
Right.
So routinely, we want to disclose the existence of this asset, so we're going to list it, but we're going to put down $1 for the value as a nominal amount, and we're going to exempt $1. And so what would happen in some cases, I saw state court judges basically limit the claim to a value of $1. no matter what you're suing for, it's only worth $1 because
Right.
under oath you listed in your bankruptcy case that it's
Right.
only worth $1.
So in that situation, would you say let's just list it as unknown?
Well, that's what I think is more likely
Yeah.
to happen at this
Yeah.
point,
Right.
or list it for a whole lot. But
Right.
I mean, so this whole way of approaching things has been problematic from the standpoint of what's in the best interest of creditors. And I think that the case law is working its way towards a situation, finding situations where that's not fair. What's the best approach?
Right.
Maybe not let the debtor benefit from misdeeds, but don't let the defendant and the cause of action benefit from some technicality or something that the trustee or the creditors had nothing to do with.
Right.
I agree with that.
Yeah. Well, great. Thank you. Our next opinion comes from the Third Circuit. So in Phoenician Mediterranean Villa LLC versus Swope in Ray J&S Properties, we have a Chapter 7 trustee who took control over a commercial leasehold held by the plaintiff in a building owned by the debtor. The plaintiff had been operating a restaurant in the building, but had stopped operations and had canceled its insurance. They were predicting some really bad weather in Altoona, Pennsylvania, and after an Arctic blast during which the tenant did not sufficiently heat the building, the pipes burst, flooding the building. In order to protect the building, which was the most valuable estate asset, the trustee took control of the premises, effectively evicting the plaintiff. The plaintiff sued under 42 U.S.C. 1983 for wrongful eviction, claiming violation of its 4th and 14th Amendment rights. The bankruptcy court dismissed, holding that the trustee was entitled to qualified immunity. The district court agreed. The Third Circuit also agreed, holding that bankruptcy trustees are government officials entitled to qualified immunity from Section 1983 claims when they act in their official capacity in a manner that is not contrary to clearly established law. So the majority opinion here dismissed based on qualified immunity. There's a concurrence by Judge Fisher, who would have upheld dismissal based on quasi-judicial immunity. So let's talk about those different standards and what the trustee's immunity from suit.
Well, all the judges said the trustee should win.
Yes.
The majority said that qualified immunity protects the trustee, and then Judge Fisher in the concurring opinion said that it's quasi-judicial immunity that's applicable. And when I read the concurring opinion, I thought that's right on target. I mean, I like the concurring opinion. In fact, if I'd been on the majority, if I'd written the majority opinion and then I'd been presented with a concurring opinion, I would have said, well, forget the majority opinion. I'm going to adopt the concurring opinion. Of course,
Why
I don't
is
know how
that?
it works
Yeah.
because if I've told my law clerk, draft this opinion and do it this way and convince the other judge on the panel that this is the way it should be analyzed, and everybody spent all that time on that opinion, and then the concurring opinion comes into chambers, I'm not sure I'm going to go to all these people and say, forget what I said, let's do the concurring opinion, all this time you spent, never mind. By the way, this isn't the Fourth Circuit, right?
It's the third.
All right. Okay, so anyway, but like I said, I think the analysis in the concurring opinion is more on target. I've always assumed that quasi-judicial immunity protects a Chapter 7 trustee. And what that is a form of judicial immunity. Judges are protected when acting in the course of their role as a judge. And so that type of immunity, I've always assumed, protects a trustee who's also acting as a quasi-judicial officer and
Right.
in accordance with his duties. What happened in the majority opinion is this idea about qualified immunity came up, and that was sort of invented, at least if you look at the explanation in the concurring opinion. It was something that came from a Supreme Court decision that established the ability, a Harlow decision that said that government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. And the contest came down to, well, when the trustee self-helped herself to take possession of at least some portion of these premises, she violated this self-help provision,
Right.
this state law. And the majority opinion said, well, but there's also laws that said that the trustee's supposed to do this. They have a statutory obligation to do it. And we don't think the trustee violated the state law. And we think under that Harlow decision, the trustee has qualified immunity. And in the concurring opinion, they point out that their opinion, qualified immunity is an affirmative defense. It was never raised in the lower courts.
No, it wasn't. Yeah.
Why did this court take it up?
Right.
And then the concurring opinion goes through the history of immunity for trustees under the common law and how quasi-judicial immunity developed and how it's employed, and they talked about the Barton Doctrine.
Right.
And so I think that the concurring opinion is more in line of what I expected would protect the trustee in this type of case. Why open the door to competing statutory obligations or laws that may be applicable when in this case it's clear that the trustee was performing her statutory duties, nobody disputed that she was acting in the best interest of the estate? Why put the trustee in a position where she has to explain herself when she's doing the right thing?
And on Judge Phillips' point too, I think I agree that it should be quasi, but for an additional reason, which is this trustee was sort of damned if she did, damned if she didn't. Because if she didn't go in and do it, then she's going to get a lawsuit from the secured creditor saying
Right.
this was the largest asset of the estate, and you were hand-wringing, and you didn't get in there to do that, and now you've diminished the value of the property.
Right.
And while we have no hand-wringing trustees that I know of or practice with, I think that by going to give them that additional, not a qualified immunity, but a quasi-judicial, maybe they will act more swiftly, because it certainly limits, I think, a lawsuit coming from either direction.
Right.
And then they're more advantaged by going ahead and doing what's going to protect the property of the estate.
Yeah, so there's a possibility that the Third Circuit opinion could lead to some perhaps undesirable trustee choices
Hesitation.
or hesitation.
Yeah, and maybe create more opportunities to challenge the actions of the trustee. I mean, Erica's right that you put the trustee between a rock and a hard place.
Yeah.
I mean, it's clearly best to get a court order. The provision or the both the majority and the concurring opinion agree that you have absolute immunity if you get a
Right.
court order that authorizes you to take whatever action you're required to take. But you don't always have time to do that. This trustee, I think, on the same day applied for a court order, but didn't have an order in place that authorized her to take possession of that section of the premises. And so she did not have absolute immunity, but she clearly was acting within the scope of her duties, and she was not violating her fiduciary duties to the estate. In fact, had she not taken the action, then question of whether she was actually performing her duties.
Yeah,
and I don't
for
think
sure.
either any the courts had any problem finding that immunity applied.
All right.
Great, thank you for your input on that. So our next case comes from the Seventh Circuit, and it addresses the new value preference defense. So in this opinion, Levin versus Verizon Business Global and Ray One Star Long Distance, the court addressed both the kind of transfer that cancels out the new value defense and the method for calculating the new value. Here, the Chapter 7 debtor, One Star, had paid MCI, one of its wholesale suppliers, about $1.9 million within 90 days before the bankruptcy petition. The trustees sued to recover the payments made to MCI as preferential transfers. Verizon subsequently bought MCI and entered the action as MCI's successor. Verizon argued that the payments were unavoidable according to 547c4 because MCI offset them by subsequently providing One Star with new value in the form of additional telecommunications services. The bankruptcy court ruled in Verizon's favor, and the district court affirmed. So there's an exception to the new value exception, and that is if the debtor pays for the new value, then the new value and the payment cancel each other out, leaving only the preferential payment. Here, the trustee made a creative argument saying that the debtor's assignment of its contract with MCI to an affiliate paid for the new value advanced by MCI. The court said, no, that transfer is not for the benefit of MCI. So was that the right holding that an incidental benefit is not enough to cancel out the new value preference defense?
So I would say yes, that is the right holding. I think the debtors or the trustee already gets the benefit on the presumption side with 547 because it's presumed a preference if it's 90 days. So now it's got to flip to the recipient to be able to establish why it meets one of the exceptions. And I think new value has always been that if you get paid for your services post-petition, that's going to cancel it out, and then you're relying on ordinary course. In this case, you used the word more politically correct than I would say, which is the trustee had a creative argument. But I think that's a really slippery slope. So all of a sudden, they get to determine what is a benefit.
Right.
I mean, an indirect benefit, that's opening a whole can of worms as far as I'm concerned and determining whether or not it directly benefited me. Because if it's my defense and you're already getting the presumption and I have the burden, even if I'm getting some benefit from that, it's not a direct benefit. So I think the trustee did try to go too far in making that analogy, and I think that the exception in 547, I think it's C4B, was correctly applied.
Yeah, and I do think one of the ways that the trustee supported that was saying, well, MCI wouldn't have agreed to it if it didn't benefit MCI, which I was scratching my head thinking, I'm not sure where the value, how that could offset the defense.
Right.
Well, it's interesting to think what mischief could come if it decided the other way. I mean, apparently this new entity was created as in order to effectuate a fraudulent transfer of
Yes,
some
it
type.
was.
And my question was, well, what if the new entity had paid the debt? What if the new entity had paid it off? What would that mean?
Mm-hmm.
Is that a defense? I mean, the statute says paid by the debtor.
That's right.
So
No.
But then on the other hand, if it's paid, you'd think there would be a new value of some type, particularly if they can collapse the new entity and make it an alter ego of the old entity.
Right.
I don't know. It just seemed to me there were facts missing from this case. I would have been interested in knowing more about what was going on with this new entity, and not that I would have said that I would hold a different way, but I just think that it would be interesting to see exactly what was happening in this particular case, because it was termed a scheme to avoid the debtor's creditors, and it was failed by the filing of the involuntary petition. And why should the debtor benefit from a scheme to establish an intermediary? Well, okay, but there's really not much to explain what actually happened.
Right.
Those are conclusions. And so I just think it's an interesting case to analyze, but I certainly wouldn't want to set a precedent where in order to thwart potential preference claims, debtors and creditors go out and create new entities. I don't know. But I'm also looking at the Bill Rochelle's Daily Wire. Mm-hmm. And he talks about this creation of the new value defense. You're talking about how they had averaged out the daily
how they calculated
benefit, how
Yes.
they calculated, mm-hmm. which I would have looked at as a finding of fact, maybe, or at least considered that as a factual finding as opposed to a legal analysis. But if you look at this is what jumped out at me, because Bill Rochelle says, for bankruptcy nerds, the most important feature of the case involves calculation of new value defense. And my question is, what's a bankruptcy nerd?
I think we're qualifying right now.
And everybody watching.
Well, I mean, my wife would say it's redundant. My college friends would say, well, I was already a nerd. So when did I become a bankruptcy nerd? Well, when I started getting into bankruptcy, which makes it sort of a subspecies of nerd.
I guess so.
But then the other question is, who reads this other than bankruptcy nerds?
Right.
So it's applicable to everybody. But I do think that the calculation of the new value was done in a fashion that could be interpreted as a factual finding, and so I'm not real sure what the basis would be to challenge it.
Yeah, I agree. I mean, the per diem calculation is something that we're seeing a lot with monthly service bills, because new value and when the payments are made depends on timing.
Sure.
And so the trustee in this case was saying, wait a minute, if certain money was paid for services on a particular day and you're just going to calculate up what 30 days is, divide by 30, and then do it that way, that's not really fair because it comes down to timing. And I understand that argument, and I don't think that's a bad argument. But I also think that these types of calculations are always difficult, but I agree with the judge, which is this is a factual determination. They should be going and looking, and maybe it's more work, but maybe you do have to go and see what it is per day if you're able to calculate that out. And I don't know if they were or not in this particular case. I just knew they were heavily concentrated on certain days, which would have meant the difference between them being able to keep it versus it falling into one of the exceptions under 547.
Right.
You know what else is interesting about this? Because he points out that this was Judge Richard Posner's last opportunity to opine on a bankruptcy appeal because he was one of the 3 judges on the panel. Well, according to the opinion, the case was argued in November of 2016 but not decided until September of 2017. And Posner was on the court until the beginning of September. So what do you think happened? You think he was just saying basically, I don't want to deal with this. I don't want to go out on a bankruptcy case. I don't want to be a bankruptcy nerd or have my legacy somehow influenced by that. But he didn't join in on the case, and the other 2 judges decided it without him. So I'm not, maybe there's a reason for that. I don't know.
I'm sure he had no input either behind the scenes.
Yeah. and he's not on the Fourth Circuit, right?
Yeah.
No,
right, you're
definitely
good.
not.
Okay,
You're good.
Okay.
Great, thank you. So next we turn to a Chapter 13 case. The next opinion from the Bankruptcy Court in the Western District of Louisiana addresses an issue in what's known as a no money down Chapter 13. The district had previously had a standing order regarding a no-look fee, which provided that the attorney's fees payable under the order included any expenses advanced by the debtor's attorney, effectively requiring the attorney to eat those expenses. In Ray Riley tested the district's new standing order, which is silent as to whether the no-look fee includes expenses advanced. In this case, the attorney had advanced the filing fee, the credit counseling fee, and the fee for the credit report, all to be paid through the Chapter 13 plan. The court considered whether an attorney can be reimbursed under 330 for the filing and credit counseling fees advanced to the debtor. The court in this case held no, because these fees are pre-petition expenses of the debtor that provide no benefit to the estate. And so, this case can be a springboard to discuss more generally the use of no money down bankruptcies. But do you see many of these in your court?
Not that I know of.
Okay.
I mean, we have a lot of Chapter 13s. I expect there's some, but they're not brought to my attention routinely. Chapter 13 is more so than in the other chapters, I think, a local type of practice. I mean, different courts have different ways of doing things, and different dynamics happen in different courts. And maybe in Louisiana, where this case was decided, there's a whole lot of no money down Chapter 13s, and that's the way they're done. Apparently that is the way they're done.
Right.
But the difference between districts and maybe even divisions is reflected in this new model Chapter 13 plan,
Yes.
which most jurisdictions are opting out of because they like doing things the way they've been doing them. Once again, it goes back to the New Mexico case. If something works, why mess with it? Well, what happened in this case was the court messed with something, and what they messed with was how much money attorneys can make.
Right.
And so when you mess with that, you're going to get challenged. I mean, they had a previous practice where attorneys could advance filing fees and credit counseling fees and then collect those back during the pendency of the case. And then they changed the rule and said, you know what, that's not legal. We can't do that. The law doesn't allow that because these are pre-petition obligations and they shouldn't be paid out of the estate. And so we're going to change it. And so the lawyers all got together and said, we're going to challenge it. And they picked the guy maybe they thought would be the best one to do that. And apparently he didn't work. It didn't prevail. So this is the rule now. And it may be the rule in most cases because I think the analysis is correct. It's although in our court, we have a no-look fee that permits recovery of the filing fee, if that's advanced. It's in addition to the no-look fee.
Oh, okay.
And
But it's only for the filing fee.
it's only for the filing fee. And courts have different ways of doing things and different things that they approve, but when you change things, you get people up in arms, and that's what happened in this case. And the court pointed out that there's an opportunity for debtors to pay the filing fee in installments.
Yes.
And that's an option in this case. They don't have the money to pay, they can pay in installments,
Right.
and they have to. But then they still have to have a little bit of money,
Right.
and then they have to have the money for the next installment payment and the final installment payment, and they're making those installment payments at the same time they're supposed to be paying all of their projected disposable
Right.
income to the Chapter 13 trustee. So that's a bit problematic too. But at the end of the day, I mean, you get what the no-look fee says you can get, and so maybe at some point the court will reconsider the amount of its no-look fee. Our no-look fee has a cost of living component to it, so rather than have to go back and look at it periodically, it automatically increases based on the cost of living. And we did that primarily so we wouldn't have to continue to reevaluate it. But yeah, it's a case where it reflects what is often reflected in most of these cases, and it's all about how can I get paid and how much can I get paid and who gets what money.
I agree with that. I think when you read this case, if you don't know much about bankruptcy, for me, the human element of it originally came through until I actually didn't know that you could pay the installments over a period of time. Because the first thing I'm thinking, geez, this guy is actually stand up. He's trying to allow people the opportunity to get the benefit of the bankruptcy. It's not as though he's, trying to get something that he has in advance. He's recovering expenses that allowed somebody who might not have otherwise been able to utilize the benefits of the bankruptcy. But I think in this case, I think the court came out the right way, which is either these are going to be included or they're not. And going to Judge Phillips' point, our jurisdiction and certainly in the bar that we practice in, all the attorneys got together and said if everything's going to be included, it's got to be a higher dollar amount. And I think that's what's going to happen here because it's too difficult if you're really going to be a strict constructionist in interpreting the statute and saying that these post-petition payments don't benefit the estate, they benefit the lawyer, then you're going to lose on that.
Right.
So I think that case hopefully will make a change if there's that many of them there and there is a benefit to increasing that amount so those fees can be included, then hopefully that would solve the issue.
Right.
Yeah, the practical concern is that individuals who probably should file Chapter 7s or file in Chapter 13 solely to finance their attorney's fees, and that's not a good thing.
Right.
Somebody's in a bankruptcy case usually anywhere from 3 to 5 years, and if the whole purpose of it is to finance the attorney's fees, well, anything can happen over 3 to 5 years, and there's a lot of reasons to not want to be exposed for that period of time. And so a lot of courts believe that's not an appropriate way to file a Chapter 13. They don't like the fee-only finance Chapter 13s. But the problem is, well, how can you do a Chapter 7 if you have to get your money up front if you can't collect fees post-petition? And I think that issue's been raised in connection with this these committees that are reviewing Chapter 7, Chapter 13
Yes.
type cases. Is how do you get around this situation where somebody needs to file a Chapter 7, they don't have the money, or maybe they don't have any more than what it takes to pay the filing fee. How can they pay for their attorney services?
Well, that raises a really important policy question,
Right.
and here I can put in a plug for some of my fellow academics. Pamela Foey, Bob Lawless, Katie Porter, and Deborah Thorne just published an article in the Southern California Law Review that concludes that the debtors who enter into those no money down bankruptcies are similar to Chapter 7 filers, but have their cases dismissed 18 times more often than Chapter 7 filers.
course.
Right, yeah,
So,
no question.
Yeah.
You can't. I mean, you got to keep it going for 3 to 5 years. If you miss payments to the trustee, if you lose your job, if something happens,
Yep.
you got other expenses, then the case gets dismissed. There's not a real high success rate in Chapter 13s like there is in
Right.
Chapter 7s because you're in 3 or 4 months later, you're out.
Sure. There's not even in cases that are not no money down bankruptcies.
And if you're going to get the advantage of a no-luck I mean, the quid pro quo for that then is you don't have to submit fee applications.
Right.
So there has to be a greater degree of scrutiny on what's included and what's not, because if people are abusing the system, as your colleagues probably pointed out in there, meaning they should have been 7 in the first place, but for whatever reason that they ended up being in 13, then the courts have to look at that carefully, I think.
Yeah.
Yeah, lawyers, generally as a rule want to do a good job for their clients. They want to help their clients, and I understand that. But they also want to get paid, and they want to get paid as much as they can get paid. And so there's higher fees for Chapter 13s than for Chapter 7s,
Absolutely.
and it plays into the lawyer's hands. And so if there were a way to address that problem, it would make things better for everybody.
Absolutely. Well, believe it or not, we've gone an hour.
Wow.
So Judge Phillips and Erica, that's all the time we have for today, and I want to thank you for an insightful and lively hour discussing these important cases. And we want to thank our audience for watching. Remember our archive of episodes at ionbankruptcy.com. Please mark your calendars for our next show to air on Thursday, November 30th, same time. Until then, this is Juliet Morangello on behalf of the American Bankruptcy Institute, reminding you to elevate your understanding and keep your eye on bankruptcy.